All rise. We will have The International Criminal Court is now in session. L'Audience Cour Pénale Internationale est ouverte. Please be seated. Pouvez-vous s'asseoir?
Good morning, everybody. Court officer, please call the case.
Thank you, Mr. President. The situation in the Democratic Republic of the Congo is the case of the prosecutor versus Bosco Ntaganda. Case reference ICC 0104-0206. We are in open session.
Thank you, court officer. It has been a while since our last hearing, so first of all, allow me to welcome back the parties, the participants, and Mr. Ntaganda, the accused. I also welcome those who are watching this hearing from the public gallery and also those who are watching us via the internet. Before I explain the purpose of this hearing, please, as I usually state, the appearances for the record, starting with prosecution, please.
Mr. President, the prosecution is represented today by Ms. Nicole Sampson, senior trial lawyer, Diane Luping, trial lawyer, Eric Iverson, trial lawyer, Marion Rabanit, associate trial lawyer, Christy Sim, assistant trial lawyer, Rens van der Werf, associate trial lawyer, Laura Morris, assistant trial lawyer, Selam Yurgu, case manager, and myself, Fatou Bensouda, prosecutor.
Thank you, Ms. Bensouda. Now, defense, please.
Bonjour, Monsieur le Président. Bonjour, Madame et Monsieur les juges. Bonjour à toutes les personnes présentes dans la salle d'audience, représentant Bosco Ntaganda ce matin. Mademoiselle Annabelle Gagnon-Bischoff, Mademoiselle Constance Renches, Mademoiselle Sandrine de Sénat, Mademoiselle Margot Portier, Maître Marlène Yaya Hague, Maître Christopher Gosnell, Maître Didas Nirinkwaya et moi-même, Stéphane Bourgon. Merci, Monsieur le Président.
Thank you, Mr. Bourgon. And now, legal representatives of victims, please.
Merci, Monsieur le Président. Les anciens enfants soldats sont représentés par Alejandro Kiss et par moi-même, Sarah Pellet, conseil au bureau du Conseil public pour les victimes.
Bonjour Monsieur le Président, bonjour Madame, Monsieur le Juge. Les victimes des attaques sont représentées par Anne Grabowski, juriste associée, Chérine Luzaïzou, conseil sur le terrain, et moi-même, Dimitri Soproun, conseil au bureau du Conseil public pour les victimes.
Thank you, Ms. Pella. Thank you, Mr. Superun. And for the sake of completeness, I have to add that trial chamber is composed of Judge Kuniko Ozaki on my right, Judge Chang Ho Chung on my left, and myself, Judge Robert Fremer. We are here today, tomorrow, and most likely also on Thursday, for the closing statements of the trial in the case of the prosecutor against Mr. Bosco Ntaganda. Let me first briefly recapitulate procedural history of the case. On 2nd September 2015, the trial proceedings commenced when the charges were read out to the accused and when the parties and participants made their opening statements. Since then, over the course of 248 hearings, we heard witnesses called by the prosecution, the defense, and on behalf of the victims. 102 in total. as regards victims, 2,123 of them have been authorized to participate in this trial, and 5 of them presented their views and concerns in person. Over the last few months, the Chamber received written closing submissions from the parties and the legal representatives of victims, in total more than 1,400 pages. During the coming days, they will present their cases orally and make their final submissions before the Chamber retires to deliberate. Today, we will first hear the closing statement of the prosecution. This is going to be followed, probably tomorrow morning, by the closing statements of the legal representatives of victims. And after that, the defense will present its closing statements, which might be followed by an unsworn statement by Mr. Ntaganda. The defense submissions may last until Thursday morning. Then, if requested, the prosecution and the defense will be given an opportunity to make brief submissions in response or reply to the submissions made by the respective other party. As the last point, the defense team for Mr. Ntaganda or Mr. Ntaganda himself will have then the chance to have the last word. I would like to also remind you that we set up some time schedule, but it's not rigid. We will have to remain flexible. The first session should take approximately till 11 o'clock. Now, are there any questions concerning my introduction? I see it's not the case. So now we can turn to prosecution. Ms. Bensouda, you have the floor.
Thank you, Mr. President. Mr. President, Your Honors, at the beginning of this trial, 3 years ago, the Office of the Prosecutor submitted that the evidence will prove beyond any reasonable doubt that between the 6th of August, 2002, and the 31st of December, 2003, Bosco Ntaganda, a notorious commander known as the Terminator, is criminally responsible for crimes against civilians and for the systematic recruitment and use of children under the age of 15 as soldiers in his armed group, and for their rape and sexual slavery. Today, we stand before this chamber to submit that the evidence has proven beyond all reasonable doubt that Bosco Ntaganda is indeed guilty of the crimes charged against him. The evidence tendered during trial proves the truth of witness P. 859's testimony to the court. The UPC's sole objective was to target the Balendu. Everybody knew that. It was the Lendus who were the real targets. This is what P. 859 said. The evidence, Mr. President, proves the truth of rape victim P19's testimony, which I recall here. Did you hear the UPC soldiers talking about the rapes? He said, yes, they talked about it. What did they say? He answered, they said that the Lendu were useless wild animals and we can do with them anything we want. They are not humans. Mr. President, the evidence proves the truth of witness P. 105's testimony of the UPC's murder of nearly 50 people, mainly Lendu, in Kobu in February of 2003. I quote, a lot of people were executed by hand with machetes. They used strength to execute them. Some of them were disemboweled, even pregnant women as well. They took the fetus out of the women. And you don't use a rifle to do that. You use something else in order to disembowel a woman. All that made me very sad the civilian population arrived to identify their families, it created great sorrow, the witness said. The evidence supports UPC Commander P768's testimony that the accused explained to UPC troops that the Lendu were the enemy and that, unquote, you had to kill them and eliminate them. The evidence presented at trial exposes the full spectrum of the UPC's targeted and violent crimes committed in two main charged attacks, as well as against children within its own ranks. The crimes, Mr. President, were not random. They were neither isolated or spontaneous. They were part of a carefully planned, coordinated, and executed campaign of violence, deliberately targeting the Lendu and the Ngiti civilian populations and other non-Hema ethnic groups. Deliberately targeting youth, including children under the age of 15, to recruit, use, rape, and sexually enslave in its forces. Mr. President, Your Honors, these proceedings would not have been possible were it not for the courage and commitment of the witnesses who have come before you to testify. Those who were raped, enslaved, maimed, and pillaged. Those whose loved ones were killed by the UPC. Those whose children were recruited, used, raped, or sexually enslaved by the UPC, and of those who were members of the perpetrator group and have told you of the crimes that they and their fellow soldiers and commanders committed during the conflict. The pursuit of justice and the establishment of the youth in these proceedings owes such individuals a debt of gratitude for their truthfulness, their willingness to come forward and tell the court what they know and of their experiences. Mr. President, Your Honors, Bosco Ntaganda and his co-perpetrators conceived a plan to assume the military and political control of Ituri and expel the non-Hema civilian population. By controlling Ituri, they not only had significant military and political reach, they also gained enormous economic power. Power meant to benefit themselves and the Hema community. The Lendu, Ngiti, and non-Hema civilian population stood in the way of this plan. Bosco Ntaganda and those who joined him drove out non-Hema civilian population to gain control of the territory, aiming to ensure that they would not return. Bosco Ntaganda and his co-perpetrators not only terrorized the civilian population, they terrorized their own troops. They forced the children in their army to kill. They treated them cruelly. They raped and sexually enslaved them. Witness P758, who was only 13 at the time, poignantly described for the chamber the pervasive and degrading sexual violence within the UPC. And I quote her testimony. Was any term used to describe the female soldiers? She was asked, and she answered, yes. What was the term? They called us the Guduria. She was questioned, why did they call you Guduria? She said, because soldiers who wanted to could sleep with us, and that's why they called us Guduria. She was questioned further, what is a Guduria? And she answered, Guduria is a cooking pot in which you prepare soldiers' food. And when she was further questioned about how did you feel when you heard people refer to you and other women and girls at the camp as Guduria? She answered, I didn't feel well. It wasn't a good name to call somebody. It's a very bad name. It means that the food prepared in this cooking pot is eaten by any soldier. And that's how they treated us. Any person who wanted to sleep with us could do so. That was her testimony. Mr. President, this is a landmark case in recognizing that the rape and sexual slavery of soldiers by members of the same armed group is a war crime for which this court is empowered to prosecute and convict. The evidence presented at trial proves these horrific sexual crimes beyond reasonable doubt and proves Bosco Ntaganda's criminal responsibility for them. On the strength of the prosecution's evidence in this case, which I submit confidently meets the applicable standard of proof at trial, the accused must be convicted for the crimes charged. Mr. President, Your Honors, the evidence shows that Bosco Ntaganda was one of the highest and the most experienced military commanders in the UPC. He planned, he coordinated, and commanded the two attacks of November 2002 and February of 2003 with Floribert Kisembo and other UPC commanders. The evidence supports UPC soldier P907's testimony that Bosco Ntaganda planned the war and was in charge of all the war operations. The evidence supports the accused's own testimony when asked if he was viewed as the real operational leader of the army, to which he replied, Bosco Ntaganda said, I was a tactician. I certainly accept that. The evidence proves that Bosco Ntaganda personally committed crimes. He persecuted and attacked civilians. He murdered them, pillaged their goods, destroyed their churches and hospitals. He enlisted and used children under the age of 15 to participate directly in hostilities. He also made other essential contributions to the common plan to assume military and political control of Ituri and drive out the UPC enemies that included the Lendu, Nande, and other non-Hema civilian population. He recruited, trained, and organized the army, distributed weapons and ammunition, deployed troops, ensured compliance with orders, developed UPC's communication ability, issued orders to attack, pillage, rape, persecute, and kill, and induced the commission of crimes. Crimes of this scale and of this nature required Bosco Ntaganda's direct commission and his essential contribution to their planning and organization. They required Bosco Ntaganda's will to be executed. As a military commander, Bosco Ntaganda failed to prevent or punish the crimes committed by the troops under his effective command and control. His orders were executed automatically. He knew or should have known that his troops were committing or were about to commit the crimes. These were the same troops that had committed crimes in other attacks using the same brutal tactics. While Bosco Ntaganda conceded that he could discipline his soldiers at any time, he did not discipline any soldier for the charged crimes. Mr. President, Your Honors, despite the defense claims to the contrary during trial, this was an exemplary trial in terms of fairness. The accused chose an experienced legal team to represent him during the proceedings. He had the full and early disclosure of the prosecution's witness statements and expert forensic and documentary evidence. He had the opportunity to cross-examine the prosecution witnesses, and he did so. He fully tested the evidence that incriminates him. Mr. Ntaganda was also given full opportunity to present his own witnesses, evidence, and arguments, and he testified at great length in his own defense. The chamber took reasonable and necessary measures to address indications of witness interference or disclosure of confidential information by the accused or his associates. The chamber restricted the accused's telephone contacts and visits during the trial and regularly reviewed the ongoing need for the restrictions. The chamber's decisions were fair and ensured the integrity of the trial. There is no doubt that this chamber ensured a fair trial, which is a cornerstone for the authority of the International Criminal Court. To conclude, Mr. President, Your Honors, the evidence in this case proves beyond a reasonable doubt that Bosco Ntaganda is guilty of the charged crimes, and the prosecution asks Your Honor to so find. My colleague, Ms. Nicole Sampson, the senior trial lawyer of the case, will now present overviews of the evidence adduced at trial and the scope of the charges. She will also summarize the evidence relating to the charged crimes committed during the first attack in November of 2002. Ms. Marion Rabanit will then address the chamber on the evidence relating to the second attack in February of 2003. Ms. Christy Sim will elaborate on the evidence of the crimes against children in the ranks of the UPC. And Ms. Diane Looping will reveal the evidence of the accused individual criminal responsibility for the charged crimes, for his direct and co-perpetration of them, for his orders and his inducement to commit crimes, and for his contributions to the commission of crimes by persons acting with a common purpose under Article 25. Mr. Eric Iverson will then present the key evidence and issues relevant to the accused's individual criminal responsibility as a military commander under Article 28. I thank you, Mr. President, Your Honors.
Thank you very much, Ms. Bensouda. And now floor goes to Ms. Sampson.
Mr. President, Your Honors, I will now present a more in-depth overview of the prosecution's case and the evidence heard at trial. Bosco Ntaganda is charged with 18 counts of war crimes and crimes against humanity committed in 2002 and 2003 in Ituri. 13 of these charges relate to violence committed during two separate but related attacks. The first, in and around Mongwalu and 4 neighboring villages over a 2-week period starting in November 2002. The second, in and around Lipri, Bamboo, Kobu, and roughly 23 neighboring villages over a 2-week period in February 2003. 5 of the charges relate to the enlistment and conscription of children under the age of 15 into the armed wing of the UPC. Their use to participate actively in hostilities and their rape and sexual slavery between 6 August 2002 and the end of December 2003. The prosecution relies on all credible evidence of record and on our comprehensive final written submissions. Our oral arguments today will highlight or emphasize our extensive written submissions and address major issues before you. Neither time nor efficiency allows us to restate the written submissions in our final brief, and we will not do so. The overwhelming weight of credible evidence in this case leaves no reasonable doubt that Bosco Ntaganda is guilty of counts 1 through 18 with which he is charged. Your Honors heard credible evidence during trial that in the course of conquering territory in 2002 and 2003, Bosco Ntaganda's forces killed countless Lendu, Ngiti, and other non-Hema civilians and forced thousands away from their homes. The goal to take control of Ituri and to drive out the Lendu, Ngiti, and other non-Hema civilians was revealed in Bosco Ntaganda's own orders during military operations and by his own words and conduct. His military subordinates, including witnesses P768, P963, P10, and P888, testified about what he said, that the Lendu were the enemy and they needed to eliminate them. This goal was also reflected in the attacks, the killings, and the ousting of large numbers of the non-Hema civilian population. Witnesses from within Bosco Ntaganda's militia and many victims consistently describe the UPC's discriminatory policy and practice. For example, you heard military insider P963 testify that, quote, it was a tribal war and the purpose was to drive out the Lendu or eliminate them, end quote. He also told Your Honors, quote, if you were a Lendu person, you were dead. Civilian or combatant, there were no good Lendus, end quote. And the evidence bears out what military insider P768 told the court about Bosco Ntaganda's order that Lendu and their allies were the enemy and that you had to kill them and eliminate them. He said, quote, every time he held a meeting, these words were said again and again. He said the same thing every time, end quote. This witness, P768, continued to say before this chamber, and I quote him again, when Bosco Ntaganda mentioned the Lendu, he did not make any distinction between civilian Lendus and combatants of Lendu extraction. All those who were of Lendu ethnicity were perceived by the troops to be the enemy without any distinction as to whether it was a civilian population or a combatant, so long as they were Lendu, end quote. Bosco Ntaganda was one of the most senior military commanders in the UPC, shaping and implementing their goals. A man whose military expertise distinguished him. By September 2002, he was officially the Deputy Chief of Staff in charge of operations and organization of the UPC. But with such extensive de facto powers that Your Honors heard him and others refer to him as the Chief of Staff. By the end of 2003, he officially was the Chief of Staff, as evidenced by the official UPC decree to this effect. The evidence proves that Bosco Ntaganda was a central figure in the command and organization of the Army for all its activities. The evidence bears out what UPC military insider P907 told you in this court, that you couldn't go to war without Bosco Ntaganda's approval. He was the person who was responsible, nobody else. And the evidence bears out what senior military insider P55 told your honors. Quote, most of the decisions were taken by Mr. Ntaganda. Why do I say that? It was Ntaganda who had more experience when it came to managing an army. That is why most of the operations were conducted by Ntaganda, end quote. And Bosco Ntaganda was feared amongst his troops and within the population. Witness P190 told your honors, quote, Bosco Ntaganda was not accountable to anyone whatsoever. He was a small lord or god, and when he said A, it was A, and when he said B, it was B, final. Everyone feared Mr. Bosco, even children feared him. When they heard that Bosco was in a neighborhood, they would go into hiding. During the course of this trial, your honors heard evidence about the men with whom Bosco Ntaganda shared the objective to take control of Ituri and drive out the Lendu and non-Hema civilian populations. As early as the summer of 2000, some of them had mutinied from the armed wing of the rebel group controlling Ituri. They resolved to form their own armed group to protect the interests of the Hema community. They united their skills and resources to execute the common plan. Although Bosco Ntaganda was not Hema, an alliance between Hema and Tutsi was not unusual, and the group needed his superior military experience to succeed. On your screen is an admitted photograph of some of the main co-perpetrators taken in 2000. Bosco Ntaganda is in the center. The alliance at this time in 2000 also included Thomas Lubanga, a Hema. He became the spokesperson for the officers who mutinied from the armed wing of the rebel group in power in Ituri in 2000. He was president of the UPC from its creation on 15 September 2000. By September 2002, he added Commander-in-Chief of the FPLC to his title. He was convicted for war crimes by another chamber of this court. Floribert Kisembo, also Hema, and one of the mutineers. He later became the UPC Chief of Staff from early September 2002 to December 2003. Prior to that time, he was Bosco Ntaganda's deputy. In December 2003, he formed his own armed group. Aimable Musinganya Saba, known as Rafiki, a Congolese Tutsi trader who supplied the mutineers with food and other logistics in 2000. In 2002, he became the UPC Chief of Security. Commander Kasangaki, a Hema, and one of the mutineers. In 2002 and 2003, he was an intelligence officer and operations officer in Commander Salumu Mulenda's brigade. In addition to those individuals, the alliance in 2000 also included Commander Chaligonza, a Hema, and a mutineer. In 2002, he was second in command of the UPC's Southeast Sector. And Commander Bagonza, a Hema, a mutineer who became a senior UPC military commander. In the summer of 2000, Bosco Ntaganda had also formed an alliance with Chief Kawa, an important Hema customary chief of Mandro. Chief Kawa did not have a military background, but he was instrumental in obtaining weapons for the UPC in the summer of 2002 and providing land for a UPC military training camp in Mandro, which was to become the UPC's largest military camp and weapons depot. In September 2002, he was appointed the UPC Deputy National Secretary for Defense, a position he held for only a short time. Thomas Lubanga officially expelled Chief Kawa from the UPC in early December 2002. In early 2003, Chief Kawa formed the armed group PUSIC. The co-perpetrators' initial military alliance in 2000 evolved into the political military organization, the UPC-FPLC. These mutineers adopted a political agenda when Thomas Lubanga became their spokesperson. They created the UPC on 15 September 2000. The co-perpetrators sought to solidify their political and military alliances, recruit youth for their army, and train them. These recruits, even in 2000, included children under the age of 15 years. The co-perpetrators viewed the group controlling Ituri at that time, known as the RCD-KML, as a group that favored the Lendu and non-originaire, such as the Nande, over the Hema. By April 2002, the co-perpetrators organized a second revolt from the governing rebel group in Ituri. They set up their base in Mandro and took control of part of Bunia town, with the other part still under the control of the RCD-KML forces. Between May and August 2002, Bosco Ntaganda and his men carried out large-scale recruitment and training, including of children under the age of 15. Between 6 and 9 August 2002, the UPC, with Ugandan forces, attacked Bunia and drove out the RCD-KML. During the takeover of Bunia, as the evidence has shown, the UPC launched targeted attacks against the non-Hema civilian population, perceived to support the RCD-KML. On 11 August 2002, just 2 days after the takeover of Bunia, Thomas Lubanga issued a declaration asserting political, economic, and military control of Ituri. This decree, admitted in evidence, was referred to as a foundational document in all subsequent UPC decrees. Your Honors heard evidence that from at least mid-2002 to the end of 2003, the UPC was an organized armed group. It had an established military structure, a large complement of trained soldiers, means of communication and transport, weapons, ammunition, and financing. It engaged in fighting with other organized armed groups capable of engaging in protracted armed violence. Your Honors, as the evidence proves, the crimes charged occurred within the context of a non-international armed conflict that ravaged Ituri for over 1 year. The crimes were also part of a widespread or systematic attack against a civilian population, covering a large territory and harming a large number of victims. The prosecution presented 80 witnesses during this trial. 19 were former members of Bosco Ntaganda's militia, the UPC-FPLC. Some of them were foot soldiers, and others were commanders. Some had a close working relationship with the accused, others did not. 5 of these witnesses testified that they were under the age of 15 when they were recruited by the UPC. trained to be fighters, brought to battle, or used as bodyguards and messengers, stationed at roadblocks and on patrols, and raped and sexually enslaved. 2 witnesses were members of the UPC's political wing. Another 4 witnesses were associated with the UPC or other political groups in Ituri at the relevant time. 3 witnesses were parents of UPC child soldiers. 7 witnesses were members of local and international NGOs and the United Nations. These were neutral external observers of the crimes committed by the accused. In most cases, they recorded what they saw at the time of the events. These contemporaneous records and comprehensive reports were introduced during the trial to corroborate their testimony. 11 prosecution witnesses were experts, including on destruction identifiable in satellite imagery, on forensic anthropology, pathology, crime scene investigation, and DNA testing related to exhumation evidence. It also included experts on trauma, sexual violence, and on medical assessments of victims and witnesses. 31 witnesses called by the prosecution were direct or eyewitnesses or victims of the crimes during the 2 charged attacks. Several other witnesses testified from various vantage points, having been in Ituri at the relevant time. Prosecution witnesses came from diverse ethnic groups from within and outside of Ituri. The trial record also includes contemporaneous records from the UPC itself, including Bosco Ntaganda's own radio communications logbooks, official UPC letters, orders, reports, decrees, and statutes, videos of training camps where children under the age of 15 were being trained, videos of other UPC rallies and events, and videos taken shortly before and after UPC attacks. These documents reveal the group's structure, orders, communications, and its common plan to take control of Ituri by all means, including by the commission of the charged crimes. I will pause briefly on 2 critical pieces of evidence, Bosco Ntaganda's 2 radio communications logbooks. One of his logbooks contains over 450 messages transmitted daily between November 2002 and February 2003, as well as 76 verbal situation reports from the field. A second logbook is comprised of supplementary pages which contain close to 30 additional messages and situation reports between October 2002 and June 2003. The logbooks prove what military insiders told this chamber, that Bosco Ntaganda issued orders to troops, informed subordinate commanders about promotions, implemented changes to the UPC military structure, allocated ammunition and weapons, and ordered or was informed of disciplinary measures and troop deployment. The logbooks also show that he communicated directly to the Chief of Staff, Kisembo, and with President Lubanga. The logbooks show compliance with Bosco Ntaganda's orders from his troops. It gives a picture of the daily operational military activities of the UPC, and importantly, the logbooks reveal the extent of Bosco Ntaganda's command of the first and second attacks. The prosecution's case against Bosco Ntaganda is not based on one single piece of evidence. Rather, Your Honors, it is based on the totality of the evidence of the fact and expert witnesses who testified, and of the documentary, photographic, and video evidence presented. These items of evidence create a seamless web of corroborated evidence and establish Bosco Ntaganda's criminal responsibility for the charged crimes. The defense would have Your Honors believe that most prosecution witnesses, in their various roles and from their different vantage points, have fabricated their incriminating evidence against the accused. It argues that those who directly participated in these assaults and committed crimes or saw them being committed, those who were direct victims, those who reported on the aftermath of the assaults, or who worked closely with demobilized UPC child soldiers, are deceiving the court or are entirely mistaken. Your Honors, it is simply not credible that a majority, if not all, of these fact witnesses would come to lie, come to falsely incriminate the accused. Many of these witnesses are unknown to each other, nor has the defense supported its assertions of bias or fabrication with any credible evidence, or provided any explanation or theory for what would amount to a large-scale and complex scheme to deceive the court. Not only does the defense fail to explain why military insiders from different ranks and territories, local and international NGO and United Nations staff, UPC political staff and persons associated with the UPC, a broad spectrum of victims over 2 separate attacks in 2 different areas, families of former UPC child soldiers and representatives of other governments, the judiciary, and political groups, would all deliberately collude to incriminate the accused. But also, the defense fails to identify or explain how this plan was conceived, coordinated, or achieved. These baseless assertions must be rejected. The evidence of the 19 insider witnesses alone should be sufficient to satisfy Your Honors that there is no reasonable doubt that UPC forces committed horrendous crimes against the non-Hema civilian population of Ituri, recruited and used children under the age of 15, raped and sexually enslaved them. And their evidence proves that Bosco Ntaganda bears responsibility for those crimes. These high, mid, and low-level insiders provide detailed descriptions of the UPC's structure, communications, the planning and execution of military assaults, the intentional targeting of civilians, the crimes committed by the troops, the lack of punishment for those crimes, and critically, Bosco Ntaganda's central role within the organization and in the establishment and pursuit of its policies. Bosco Ntaganda claims that he and the other co-perpetrators could not have had a plan to occupy Ituri, expel the non-Hema civilian population, and take over their territory. He says the UPC was a movement working only to establish peace in the region, embracing all ethnic groups in Ituri, and sought to protect them from harm. As the evidence on the record shows, the truth was very different. The public remarks of UPC military leaders does not undermine the critical evidence of their very own troops, as presented meticulously by the prosecution. Numerous insiders confirm that the UPC was targeting civilians, as the targeted civilians themselves also confirmed, for Your Honors. The UPC practice and policy was very different from its public discourse. At the same time as they spoke of establishing peace, UPC leaders were building an army, securing weapons and ammunition, waging assaults in various villages throughout Ituri, and planning, ordering, inducing, and tolerating the commission of crimes. The evidence proves beyond reasonable doubt that through his continuing participation in the common plan, the accused is individually criminally responsible for these crimes, which he intended or knew would result in the ordinary course of events. In addition to his liability for his participation in the common plan, the evidence clearly proves that this accused ordered, induced, and contributed to the commission of crimes by persons acting with a common purpose. He intended the crimes and knew their commission would be assisted by his actions. The evidence also proves, to the requisite degree of certainty, that the accused is responsible for the charged crimes because he failed to prevent or punish the crimes which were committed by his subordinates, over whom he had effective control, crimes the commission of which he knew or had reason to know were about to be committed or had been committed. Instead of preventing or punishing these crimes, Bosco Ntaganda, in fact, rewarded the perpetrators by promoting and praising them. The prosecution's evidence in this case is consistent and corroborated, including by defense evidence, as noted throughout the prosecution's final closing briefs. The prosecution's evidence is also credible because it withstood rigorous scrutiny. It was fully tested on cross-examination, and the defense and the accused had the full benefit of disclosure of prior witness statements and associated documents in order to test the accuracy of the witness's testimony. The accused testified himself at great length during this trial. His evidence is the principal evidence, and on many issues, the sole evidence upon which the defense relies. His testimony must be considered very carefully, and we suggest that when this chamber does so, your honors will determine that it should be given very little weight in relation to the accused's self-serving denials of his command and authority in the UPC, the commission of the charged crimes, his personal commission of crimes, the ethnic dimension to the conflict in 2002 and 2003, and the recruitment and use of children under the age of 15 by the UPC and their rape and sexual slavery. Where the accused's testimony is implausible, it is contradicted by credible evidence, and the chamber should reject it. Where his testimony reveals internal contradictions and shifting positions or recent fabrications, your honors must also reject it. First, the accused's evidence on key points is inherently incredible and internally inconsistent. For example, Mr. Ntaganda told your honors that he, within the UPC leadership, was working towards peace in Ituri and fully engaged in the peace process in 2003. As such, it would be reasonable to conclude that it would be vitally important for him to know of all activities from his own troops that would undermine this so-called peace process. Yet amazingly, Mr. Ntaganda would have you believe that he was unaware of a complex, coordinated attack on over 20 Lendu villages in and around Lipri, Kobu, and Bamboo in February 2003. He knew nothing about that. He, the Deputy Chief of Staff in charge of operations and organization, that is incredible. He knew about these events, of course, because he was intimately involved in planning the operation. An operation that resulted in a massacre of Lendu civilians in and around Kobu, Lipri, and Bamboo, their rape and sexual slavery, the pillage of their goods, the destruction of their property and of their churches and hospitals. Mr. Ntaganda's evidence was also incredible on straightforward questions about the level of planning, coordination, and authorization needed to launch a UPC attack on different locations in February 2003. The accused, an experienced military tactician, was asked during his testimony in chief whether he agreed that military operations require careful planning. At that point in his testimony, he answered, and I quote, "That's obvious. You have to have preparation within the Army. Before starting an operation, there are numerous preparations to be made, not only weapons and ammunition." Close quote. He further explained in his direct examination the level of coordination required during attacks, and I'll quote his evidence again. "To be able to overcome the enemy, one has to give proper orders to the soldiers and also to monitor the unfolding of the fighting, so that one is able to know where to deploy more forces. As the fighting unfolds..."
Mrs. Sampson, could you kindly slow down a bit? Thank you.
Certainly. "As the fighting unfolds, you then decide how the fighting or the combat has to be guided or directed." End quote. Yet, in cross-examination, Mr. Ntaganda was asked, and I quote, "You would agree that an attack on a location, in fact, on several locations, from different areas, would require careful planning and coordination in your experience?" Answer, "No." End quote. Even more implausibly, he claimed that commanders in the field could carry out attacks in February 2003 without notifying him or the UPC military hierarchy. Again, this is inconsistent with his earlier testimony that, quote, "I was really aware of everything that was going on at all times," end quote. And it is inconsistent with his claim that he arrested a subordinate commander on another occasion because he had launched an unauthorized attack. And it is inconsistent with his purported devotion to ensuring lasting peace in Ituri. Plainly, giving your troops the unfettered ability to launch unauthorized attacks on Lendu villages would undermine the peace process entirely. The truth is that Bosco Ntaganda did not engage in any sincere peace initiatives, and he knew exactly what his troops were doing at all times because he planned, coordinated, and ordered these attacks. As a second example, Bosco Ntaganda told this court that there was no ethnic dimension to the conflict in Ituri after the UPC formally took control of Bunia in September 2002, and that the UPC never once attacked Lendu or any other civilians. These assertions are wholly contradicted by consistent and credible evidence from both prosecution and, in some cases, defense witnesses, in documents and in videos, and in contemporaneous written reports, that ethnic fighting continued in 2002 and 2003 in the territories under UPC control, and that the UPC launched violent attacks against non-Hema civilians, particularly the Lendu. The evidence Your Honors heard bears out what Lendu victim P805 told the court, that the UPC was made up of people from the Hema tribe, and that he, P805, fled his area fearing that the UPC would kill him. Quote, because there was a tribal war underway between the UPC and the Lendu tribe. It was a tribal war, end quote. Other parts of the accused's testimony are recent fabrications and must be rejected. For example, before trial, the defense accepted as fact that Rwanda provided weapons and ammunition to the UPC beginning in July 2002. Before the start of trial, based on this agreement between the parties, the chamber found that no further evidence needed to be adduced to prove this fact. However, during his testimony, Mr. Ntaganda resiled from this factual agreement. He denied that weapons came from Rwanda, which is contradicted by evidence from his own military insiders. Tellingly, the defense did not challenge prosecution witnesses who testified that weapons came from Rwanda, nor did it suggest to witnesses that the weapons came from anywhere else. The first time this new position came to light was during the accused's testimony, from which the chamber can find that this was a recent fabrication. Second, just prior to the start of the defense case in 2017, the accused disclosed an alibi defense. For the first time, the accused disclosed that he was in another country during a period related to the second attack. Yet he did not once challenge prosecution witnesses who said he was in Ituri during those days, and he did not suggest to those same prosecution witnesses that he was actually in another country. Rule 79 imposes an obligation on the accused to notify the prosecution of a potential alibi defense, with names of witnesses or other evidence upon which the accused intends to rely. The very late disclosure of this potential alibi after the prosecution case ended is a basis for your honors to infer that it is also a recent fabrication and to dismiss it. Lastly, your honors, on 27 June 2017, during his testimony, when asked if recruits arriving at the Mandro military training camp were ever asked how old they were, the accused replied, "No, we didn't put major importance on that." Several months later, however, on 7 September 2015, the accused was asked, quote, "Was the question, 'What is your age?' part of the process of recruitment?" To which he replied, "It was obligatory. We had to ask them." Which part of that evidence will your honors believe, if any? Other defense witnesses. We suggest that your honors should also consider defense witness testimony with caution, where these witnesses adopted the same incredible positions as the accused on facts upon which the charges are based, and where the sheer volume of credible evidence contradicts them, such as the absence of children under the age of 15 in the UPC. We suggest that many defense witnesses came here with a bias, and that their evidence needs to be reviewed with caution because of their close personal or professional relationship to the accused, or their ethnic or political allegiances. We submit, your honors, that the defense evidence does not cast reasonable doubt over the evidence proving the commission of the crimes and Bosco Ntaganda's criminal liability as alleged. Mr. President, I will now turn to a review of the scope of the charges in this case. The charges in this case are specifically pleaded, and the accused has been sufficiently informed of the charges against him. In addition to the confirmation decision, the prosecution clearly indicated the material, facts, and circumstances underlying the charges in the 65-page updated charging document by reference to precise locations and reasonable time frames, consistent with the nature of the alleged criminality. Further notice of individual underlying criminal acts and evidence of the charges was properly provided to the accused by way of the prosecution's disclosed evidence before trial, its in-depth analysis chart, and its pre-trial brief. As the Bemba majority appeals judgment expressly acknowledged in paragraph 115, its decision is limited to the specific charges in that case. The majority found that those charges in the Bemba case were too broadly defined, both temporally and geographically, referring to crimes throughout the Central African Republic over a period of 4.5 months. The prosecution underscores that the Central African Republic is approximately 10 times the size of Ituri. As a result, the Bemba majority limited its judgment to those individual underlying criminal acts that were identified in the pre-confirmation amended document containing the charges and mentioned with approval in the confirmation decision. The Bemba majority appeals judgment does not propose to introduce a requirement that all underlying individual acts must be specifically listed in the charges. Rather, the majority expressly acknowledged that adding specific underlying acts after confirmation may be permissible without an amendment to the charges in other cases, such as this one, where the charges have been pleaded with a sufficient degree of specificity. The charges in this case differ significantly from those in Bemba. The confined temporal and geographic scope of the charges here, combined with the detailed description of the material facts and circumstances underlying the charges, is not overly broad and provides a meaningful description of the charges against this accused. The confirmation decision and the updated document containing the charges precisely define the charges in the two main attacks. Each attack is limited to a discrete 16-day period with specific details as to the circumstances in which the attacks took place on a near daily basis and on the commission of the crimes, including the nature of the accused's alleged criminal acts and those of his co-perpetrators and subordinates. The prosecution gave notice in these documents of which crimes it alleges occurred in or around which specifically named town or village. The locations of each charge are clearly defined in the updated document containing the charges for each of the alleged crimes during the two attacks. And for each attack, the crimes occurred in villages within a limited 15-kilometer radius. The defense's attempt to combine these distances or to make them larger or less defined must fail when considered against the specifics in the confirmation decision and the updated document containing the charges. The pretrial chamber's findings with respect to the specific criminal incidents were illustrative of the crimes and were not intended to exhaustively list them. By way of example, although the pretrial chamber found that 3 nuns were raped in Mongwalu in the confirmation decision at paragraph 49, the charges of rape in this location were not limited to this incident. Rather, the pretrial chamber confirmed that acts of rapes were committed generally against civilian women in Mongwalu in the 2-week period of the first attack, and cited as examples only 4 specific instances of rape. This chamber has also held that the pretrial chamber made a non-exhaustive finding regarding relevant acts of violence for the purpose of the crime of attacks against the civilian population. In addition, this chamber held, and I'm referring to decision 450, that the use of the qualifier in or around the identified villages was appropriate and could be retained in the updated document containing the charges. The chamber found that this accorded with the pretrial chamber's decision to include crimes committed in the surroundings of the villages mentioned in paragraph 36 of the confirmation decision, since the precise limits of these villages may not be clearly ascertainable. This included the geographical areas between villages, such as the pretrial chamber's confirmation of rape alleged to have occurred on the road from Buli to Kobu, or, in certain cases, immediately neighboring villages within that geographical area. This is consistent with the Lubanga appeal judgment, which found, in paragraph 124, that further detail about the charges, as confirmed by the pretrial chamber, may, depending on the circumstances, also be contained in other auxiliary documents, such as the updated document containing the charges or list of evidence. In fact, the defense concedes at paragraph 12 of its reply brief that post-charge auxiliary documents may provide further details, such as the precise name of a victim or perpetrator about an existing charge. As to the charges related to the recruitment of children under the age of 15, their use to participate actively in hostilities, and their rape and sexual slavery, these charges are framed more broadly. This is consistent with the nature of the specific crimes, the pattern of criminality, their large scale, the prolonged and continuous nature of these crimes over a 16-month period and over a larger geographical territory, where perpetrators and victims were often on the move. The pretrial chamber ruled that the formulation of these charges was acceptable, given that recruitment and use did not occur at one single place or one given time, but throughout the territory and time period. And because of the continuous nature of these crimes, coupled with the fact that the UPC was continually on the move between various locations in Ituri. And a broader formulation for these particular charges has been accepted by the appeals chamber of this court in the Lubanga proceedings. The Lubanga appeals chamber confirmed that under certain circumstances, framing the material facts as a pattern of offenses, such as a pattern of enlistment, conscription, and use of individuals under 15 years in hostilities, is permissible, is consistent with Regulation 52, subparagraph B, and is an adequate basis for a conviction. The majority of the appeals chamber in Bemba did not depart from these findings in Lubanga. Indeed, the Bemba case did not deal with these types of continuous crimes, and in fact acknowledged the possibility of adding specific underlying acts after confirmation, depending on the case. A broader formulation for the charges of recruitment and use of child soldiers has also been accepted in cases before the Special Court for Sierra Leone for the same reasons. And the charges do provide significant detail in its description of the material facts and circumstances underlying these crimes, including the UPC's recruitment campaigns in villages where Hema lived, the training of children in at least 13 training camps mentioned by name, and the use of children during attacks in at least 16 specified villages. The updated document containing the charges refers to rape and sexual slavery of child soldiers during military training and after battles, and in the residence of UPC commanders throughout Ituri in places where the UPC fought or was based. The confirmation decision refers to a non-exhaustive list of victims of recruitment, use, rape, and sexual slavery by witness code with factual details of these crimes. Although the prosecution's position is that the charges have been sufficiently and specifically pleaded, we note that even if Your Honors were to find that the material facts are not pleaded with sufficient degree of specificity before the start of trial, the Chamber must still assess whether the accused has been afforded a fair trial. In particular, Your Honors must assess whether any prejudice has been cured through further information that Mr. Ntaganda received before or in the course of the trial. And I refer Your Honors to the Lubanga Appeals Judgment, paragraphs 129 and 130. We submit that he has. Mr. Ntaganda had timely, clear, and consistent information from the prosecution throughout these proceedings. Mr. Ntaganda was informed in sufficient detail of the case against him by reference not only to the confirmation decision and the updated document containing the charges, but also to the list of evidence and disclosed witness statements, to the pretrial brief, and to the in-depth analysis chart provided by the prosecution. The defense argues that 11 specific criminal acts have no counterpart in the updated document containing the charges. This is an incorrect understanding of the charges as framed and omits from its review the confirmation decision itself. Each of those 11 underlying criminal acts fall under the material facts and circumstances described within the narrow, confined, and precise parameters of each charge. The defense had notice of 9 of the 11 incidents mentioned before the start of trial, since they were identified and listed in the confirmation decision or pretrial brief, or both. For instance, the defense cannot claim in relation to the charge of destruction of property in Sayo that no destruction other than with heavy weapons is charged, when the confirmation decision clearly states at paragraph 72 that, and I quote, UPC FPLC troops systematically shelled Sayo using heavy weapons. UPC FPLC soldiers also used incendiary grenades and burned houses while people were inside, end quote. Notice of 2 of the 11 incidents was given in court during trial. They fall within the parameters of the charges, and there is no unfairness to Mr. Ntaganda. The 10th item concerns evidence from P768 about the deaths of civilians who stepped on anti-personnel mines planted by the UPC in Mongwalu. While this evidence emerged for the first time during the witnesses' preparation session and was therefore not specifically referred to earlier, it squarely falls within the murder charges brought by the prosecution and confirmed by the pretrial chamber. The 11th item that the defense challenges relates to the evidence of a participating victim in this case. The defense had sufficient time to prepare the cross-examination of the relevant witness on the topic, and any potential prejudice was addressed. Critically, in relation to the application for this victim to give evidence before the chamber, the defense did not object to the evidence because it fell outside the scope of the charges. Rather, the defense merely argued in filing 1773 at paragraphs 27 to 29 that the victim's evidence repeats other prosecution evidence of rape in or around Mongwalu. The manner in which the accused conducted his defense, his examination of prosecution witnesses, the fact that he listed 116 witnesses whom he originally intended to bring in his defense, his own testimony over several months, as well as his closing submissions, show clearly that he has been well aware of the charges against him since the start of trial. Your Honors, I will now move to the third and final part of my presentation before this chamber. I will now address the evidence we say proves Mr. Ntaganda's UPC troops committed crimes during their multi-day assault on the Banyali Kilo collectivity during the first attack. I will start by giving you an overview of the crimes committed during this attack, after which I will address three specific defense claims. The evidence presented at trial establishes that Mr. Ntaganda and the troops under his direct command intentionally attacked civilians in Pluto, Mongwalu, Sayo, Nzebi, and Kilo, displaced or forcibly transferred the local population, and killed scores of innocent people. They raped them, pillaged their property, destroyed their homes, and persecuted them. Bosco Ntaganda and the UPC coveted Mongwalu for its gold and its strategic location. In order to capture it, Bosco Ntaganda planned a massive attack on the Mongwalu area, mobilizing an overwhelming force of heavily armed soldiers and Hema civilian supporters from several directions. This force was to attack and kill everyone they would find in the area, regardless of status, age, or gender. The aim was to take over Mongwalu and the collectivity, expel all non-Hema civilians, and dispossess them of their property. The execution of the plan began by 19 November 2002, when Bosco Ntaganda's troops were in position to attack Mongwalu and its surroundings, and when Bosco Ntaganda ordered them to advance. By 24 November 2002, they had taken Pluto, Mongwalu, Sayo, and Nzebi. On or about 6 December, they also took Kilo, completing the takeover of the Banyali Kilo collectivity. The UPC's brutal assault achieved its goal and left countless victims in its wake. The crimes committed during the first attack were neither isolated incidents nor the collateral damage of an otherwise lawful military operation. The evidence shows their large scale, systematic, and intentional commission, resulting from deliberate and meticulous planning by Bosco Ntaganda and his co-perpetrators. Men, women, and children were shot or hacked to death with machetes as the troops advanced. One witness alone, P886, found almost 50 bodies left by the UPC in various places in the streets of Mongwalu and Sayo. Other victims were captured during search operations and either killed on the spot or taken as prisoners. The UPC took captives to its camps, where it interrogated, tortured, and summarily executed them. One UPC soldier who testified in this case, P17, said that for a Lendu taken prisoner, quote, there was a 99% chance he would be killed, end quote. Several witnesses described the mass graves they uncovered and the human remains they found when the UPC left the area. In Kilo, one witness found a mass grave next to the UPC camp. It was filled with bodies, thrown, piled on top of each other. In Sayo, the UPC detained people in an underground pit located at their camp near the Catholic Church. Following the UPC's departure, the local population found many decomposing human remains behind the camp. In Mongwalu, the body of Abe Bwanalonga was exhumed at the apartment camps where Bosco Ntaganda had resided during the UPC's occupation of the town. Your Honors, the civilians who did manage to escape and save their lives had to walk long distances through dense forests to safer areas. But were they safe? They had no food or clean water, nor shelter. They faced permanent danger. If the UPC found them, they would be killed. These civilians lost everything. Back in Mongwalu and Sayo, the UPC engaged in systematic looting. UPC commanders, soldiers, and Hema civilian supporters took everything they could find: vehicles, food, televisions, radios, furniture, medical equipment, everything. Civilians who fled could not return to Mongwalu, or they would be killed or raped. UPC soldiers in Banyali Kilo raped at will. Some women and girls, including witness P912, were abducted by UPC soldiers to civilian houses where they were gang raped. Others were taken to UPC camps to sexually satisfy the soldiers, in the words of military insider P907, who stayed at one of these camps. In Kilo, rape occurred on such a large scale that antibiotics were distributed to treat the many soldiers who were suffering from sexually transmitted diseases. Your Honors, during trial, you have heard Bosco Ntaganda deny that these crimes occurred. You have heard him try to evade his responsibility for them. His defense can be summed up in 3 general claims. First, the witnesses who attested to the UPC's crimes all lied. Second, Bosco Ntaganda's army was perfectly disciplined and was simply incapable of committing the charged crimes. And third, there wasn't a single civilian left in Mongwalu when the UPC attacked, and the UPC had an exclusively military objective. During my brief submissions on the first attack, I will address these three incredible claims in that order. According to Bosco Ntaganda, the prosecution witnesses who testified about UPC crimes all lack credibility or lied in their incriminating evidence. And the evidence, he claims, is devoid of weight. In other words, the alleged crimes that they described or said they committed never took place. There were no victims, no perpetrators. The truth, however, as shown at trial, is that in making this sweeping claim, Bosco Ntaganda stands entirely alone. From different vantage points, over 20 witnesses gave consistent evidence of the crimes Bosco Ntaganda and his troops committed in Mongwalu. Let's look at the different groups of witnesses you heard to illustrate just how alone Bosco Ntaganda is in his denial. First, he stands alone against no less than 7 of his own subordinates, simple foot soldiers and senior staff officers alike, who participated in the assault and testified not only to the crimes that they witnessed, but also to their participation in their commission. You've heard the account of P963, a soldier who attacked Mongwalu with the UPC forces. He testified, quote, "We fired at everyone and then we would come across bodies," end quote. The bodies that P963 saw included women, children, and elderly people. Your Honors heard P17, another soldier, describe seeing a woman's dead body lying outside a health center as he moved through Saya with UPC troops. He testified he heard a baby crying inside the health center and that he found the baby's dead body in a pool of blood when he returned there. The baby had been thrown against a wall. The same soldier described to you some of the nightly murders of prisoners taken by the UPC. On one such night, Bosco Ntaganda ordered him to take 2 prisoners away and tie them up. The 2 prisoners were then beaten up before a UPC soldier murdered them using his bayonet, all in Bosco Ntaganda's presence. Several of Bosco Ntaganda's soldiers also admitted to looting. P907, for instance, said, and I quote, "We looted all types of goods. I, for one, looted some chairs, some beds, some mattresses, radio sets, television sets, boxes of clothing." And you see, if you took a motorbike or any item of value, the commanders will take them away from you. The troops at the market looted various shops, and they took whatever they wanted to, anything they found interesting. As for me, I took household items because I wanted to furnish my house. End quote. Another witness, P10, said, quote, "All of the UPC elements looted. As for me personally, I took a bed, clothes, shoes, drinks, cigarettes," end quote. Second, Bosco Ntaganda stands alone in his denial against over 15 civilians who suffered or witnessed the UPC's crimes during the first attack. Many of them testified that they were expelled from their homes and lost everything as a result of the UPC's assault. For example, one of these civilians, P859, fled Mongwalu with her relative when his house was shelled by the UPC. When he returned to Mongwalu, he found that all his possessions had been taken. He told Your Honors, and I quote, "The house was empty and we didn't know who to ask. The village was full of UPC soldiers. We couldn't ask anybody anything. If you ask a UPC soldier a question, he might kill you. So we spent the night on the floor." End quote. This witness later saw Hema civilians in town wearing his own clothes. In another example, witness P886, a civilian who fled Sayo after the UPC's attack and sought safety in the bush near a river for 3 days, described the hard conditions in which he and countless men, women, and children were left. He said, and I quote, "We had nothing to eat, there was no water to drink, we didn't have any fire, and it was raining. We had no shelter. We were under the trees, that's all we had for shelter." Your Honors have also heard from men and women whose family members were murdered or who barely escaped death themselves. For example, witness P22, a Lendu woman who was captured by the UPC in Kilo and put in an underground hole with other prisoners. For their own amusement, UPC child soldiers ordered another detainee to penetrate P22's vagina with his hand while the soldiers were laughing. The next day, P22 saw a UPC soldier kill a pregnant Lendu woman with a knife before he cut P22's own neck, leaving her for dead. P22 killed herself before she could testify. Her statement has been admitted in evidence under Rule 68. You have heard from witnesses who were brutally gang raped by UPC soldiers after their capture. Among them was witness P912, only a young girl when the UPC came for her. She was abducted from her home by 3 UPC soldiers and taken to a house occupied by a UPC commander. There, the commander raped her while she was held down by 2 soldiers. When he was done, another soldier took his turn and raped her too. Another woman, V2, testified that she was part of a group stopped by the UPC as they fled the attack. After separating the men from the women, the soldiers told her to hand over her child to them and lie down on the ground. When she refused, a soldier hit her in the face with the butt of his rifle. 2 UPC soldiers then raped her in the bush, one after the other, while a 3rd soldier stood aside with her children. The other women in her group were also raped. Your Honors, the evidence of over 20 of the victims and direct perpetrators of this attack paints a consistent picture of a brutal assault that is very different from the version of events described in the accused's testimony. These witnesses are corroborated by the findings of an independent international observer who interviewed dozens of victims and eyewitnesses of the UPC's crimes in Mongwalu and Kilo, and who concluded that, and I quote, "During the 6-day military operation, UPC forces slaughtered civilians on an ethnic basis. chasing down those who fled to the forest, and catching and killing others at roadblocks, end quote. Further corroboration is provided by the skeletal remains exhumed by the prosecution from 2 separate shallow graves in Sayo, which contain the remains of 6 people, including young children and elderly men. Forensic pathologist P937 determined that 4 of these 6 bodies suffered damage consistent with gunshot wounds. Forensic scientist P954 concluded that one of the bodies showed a familial DNA match with one witness who testified in this case about the loss of his relatives in Sayo. Bosco Ntaganda claims that all of these witnesses lack credibility or are outright liars. Why? Because he claims they expected to gain something from their interaction with the court, or they held a grudge against him, or because of some other far-fetched theories based on his distortion of the evidence. Now, how likely is it really that over 20 civilian victims and UPC perpetrators would testify independently of each other in this case and lie about an attack that they didn't witness and invent crimes that did not occur? Bosco Ntaganda's blanket rejection of all incriminating evidence, all the witnesses of his crimes, is simply untenable. The truth, Your Honors, is that there is only one witness in this case who had a clear, tangible interest to provide false evidence, the accused himself. Bosco Ntaganda's second incredible claim, Your Honors, is that his army was simply incapable of committing the crimes charged because his troops had been properly trained and taught about discipline. This claim should also be rejected. It is entirely based on Bosco Ntaganda's self-serving testimony. For instance, his evidence that Chief Kawa's video-recorded speech in Mandro took place just before the first attack is baseless. In fact, this event took place well before the first attack, and, as explained at paragraphs 913 to 916 of the prosecution's closing brief, this speech was made purely for propaganda purposes. Why else would a journalist be present recording the words spoken, clearly for public dissemination? Words that, if they were really military instructions on the eve of a major battle, would be the equivalent of military secrets. The reality, in contrast to Bosco Ntaganda's self-serving theory, has been consistently described by his own subordinates at trial. For instance, you have heard about the instructions Bosco Ntaganda and his commanders gave the soldiers before the Mangwalu attack. His subordinates explained that the instructions were crystal clear. Witness P963 testified, quote, "The purpose was to drive out the Lendu or eliminate all of them, loot their possessions, occupy their houses," end quote. Witness P907 testified that, and I quote, "It was clear right from the beginning that the Lendu was a sworn enemy and that if one saw a Lendu, they should be killed," end quote. And witness P768 explained that Bosco Ntaganda, quote, "didn't make a difference between Lendu civilians and the militia. He spoke about Lendus, only Lendus, and everybody had to assess that in their own way," end quote. Before the assault, UPC soldiers were also told to kupiga na kuchaj, a military term all UPC soldiers understood to mean to loot or pillage. You heard Bosco Ntaganda claim that this was a purely military expression, which means to attack and charge the enemy. Here again, the accused stands alone against 9 of his subordinates, including a witness called by the defense, all of whom testified that the expression was an instruction to pillage or loot. The order to kupiga na kuchaj announced a promise to the soldiers that they would be able to take advantage of the situation, as one of Bosco Ntaganda's soldiers, P907, described it. One UPC commander, Mulenda, told the troops that they would, quote, receive money, sleep on mattresses, have food, have women, and forget all the suffering that they endured, end quote. Should there be any doubt about the meaning of these instructions, Your Honors need only look at the evidence of their implementation. The soldiers acting on the order of, quote, kupiga na kuchaj, end quote, raped and killed civilians, burned their homes, and took war booty that included women. P17 testified it was a way of motivating the troops. P963 confirmed, if you are a soldier, the army is a place of happiness and joy for you. You will have women for free, houses for free, and everything is free when you are a soldier. He added, in general, it was to do whatever you wanted. Do as you will. P907 described the mop-up or cleaning up operations he participated in along with other UPC and HEMA civilian supporters. He said, quote, given that the inhabitants of Mongwalu had fled and that Mongwalu was occupied, we broke into houses. We searched the houses. And if we found people within the house, we would kill some. Some would be taken hostage and taken back to the camp. Civilians were involved in the pillaging. They would break into houses and loot various items. Houses were looted, shops were looted, depots were looted. Everybody took whatever they wanted to. Every soldier looted. And this lasted about a week. And if a hostage was a Lendu, that hostage would be killed if they resisted. End quote. Your Honors, this, as opposed to Bosco Ntaganda's theory, is an accurate reflection of the conduct of the UPC's attack. Lastly, you have repeatedly heard from Bosco Ntaganda's soldiers that none of the crimes they committed were ever punished. For example, P963 told Your Honors, quote, we were in the context of a tribal war, so there were no sanctions, end quote. Witness P907 said, I never heard that an FPLC soldier had been arrested for having killed a Mulendu. I never heard mention of any such thing. P768 testified, I never saw a soldier or an officer being sanctioned for having killed a Lendu. Bosco Ntaganda's description of a perfectly disciplined army is far from the reality described by his soldiers during trial. Bosco Ntaganda and his forces were neither disinterested freedom fighters, nor the disciplined and restrained army he described them to be. In fact, the only discipline Bosco Ntaganda insisted upon is that his troops obey his orders, even when they were criminal. The third of Bosco Ntaganda's incredible claims, Your Honors, is his suggestion that the civilian population fled Mongwalu and Sayo when the first shots were fired, and not a single civilian was left in the area. According to Bosco Ntaganda, the UPC could not have attacked, murdered, or raped civilians because they were all gone, and the objective of the UPC's attack was purely military. This claim is entirely implausible too, and should also be rejected. A civilian population of over 25,000 people, men, women, children, elderly people, does not instantaneously vanish at the sound of a single gunshot. The reality, again, was described by Bosco Ntaganda's own subordinates, as well as the victims of his crimes. Witness P17 saw UPC soldiers shoot and kill an unarmed man and a young girl in Mongwalu. Later, Bosco Ntaganda ordered P17 to shoot at a group of fleeing civilians. Witness P800 was with injured civilians when the UPC shot at them using grenade launchers. He was able to flee, but he left behind the injured, including a mother with her 2-year-old child. Months after the attack, the witness found the mother and child's skeletal remains in the health center. Witness P892 saw the murder of a Lendu civilian who had been hiding in Mongwalu after the attack. When this civilian left his hiding place because he was hungry, a Hema civilian supporter struck him on the head with a machete and killed him. Your Honors, equally implausible is Bosco Ntaganda's testimony that before leaving Mongwalu, the Lendu combatants took with them everything that was left in the town. And as a result, the UPC only found empty houses and nothing left to pillage. Bosco Ntaganda's testimony on this point is contradicted by 7 of his own subordinates, who, as I've already rehearsed, testified that they pillaged or saw other UPC soldiers and commanders do so in Mongwalu and Sayo. It is contradicted by 10 civilians from Mongwalu whose belongings were taken, or who personally saw the UPC troops pillage. And it is contradicted by 4 senior military UPC officers who saw the UPC soldiers and commanders, including Bosco Ntaganda himself, in the possession of the goods looted in Mongwalu and Sayo. Insider witness P907, who participated in looting in the center of Mongwalu, captured it in this way, and I quote, "We were supposed to loot systematically, take everything that we found. Each time we attacked a particular place, we were supposed to loot. And the civilians that went along with us were supposed to go and help the soldiers carry the looted goods. Vehicles, mattresses, televisions, radios, furniture, everything. As soon as we entered a house, we really couldn't pick and choose. We were supposed to take everything." Your Honor, this concludes my overview of the evidence related to the first attack. In view of the time, perhaps Your Honors wish to break at this moment and resume several minutes earlier so that we can continue with the prosecution's presentations.
Thank you very much, Ms. Simpson. Exactly, you are right. So at this moment it's 5 to 11, so we will have we will take our regular break for 30 minutes, which means that we will resume at 11:25.
All rise. Veuillez vous lever.